Hey class, Mr. Stewart here. This is going to be the integrity video for week 11, which is in criminal evidence, which we're going to be talking about chapter 14 today. Now, there is a lot of good information in this chapter, and there is no reason for you not to read the chapter probably more than once. Simply because of how much information is in here. I'm only going to be covering kind of a couple different things in this lecture today, just so that you can get it in your mind about a couple of these ways that we can go about obtaining physical or other evidence. Now, don't be alarmed if the book cover on this PowerPoint looks different than your text. I just happen to be using PowerPoints from an older edition of the text. They're really not any different than the newer ones. So I think this is the previous edition of the textbook, not the current one, but the information is the same. It may just be presented just a hair differently in the new edition. All right, so today we're going to be talking about Chapter 14, Obtaining Physical and Other Evidence. Now, you can read in this chapter what the definition of evidence is and what are some of the examples of evidence. I don't really see any need to go over that. I mean, we cover that in almost every criminal justice class that we talk about, along with a couple of these other things that we do that we're going to be talking about. But a lot of students typically get confused in regard to, number one, the difference between reasonable suspicion and probable cause. Now, probable cause, remember, is the gold standard in criminal justice. That's what you have to have in order to make an arrest. That's what you have to have in order to conduct an intrusive search, basically to violate someone's Fourth Amendment right. You have to have, at a minimum, a probable cause. Now, understand that police can have a consensual encounter with a citizen. That means that, hey, the police stops you, you're walking down the street, and the police officer says, hey, can I talk to you for a minute? And you say, yeah. And you have a conversation. That's a consensual encounter. That's not based on anything that he believes you have done. That's not based on any level of proof that he has. It's just a consensual encounter. And during that consensual encounter, if the police officer says, hey, do you mind if I search your car? And there's, and if you agree to that search, then the police officer can search that car. You're not required to agree to the search, or even if you do, you can put terms upon that consent, which means you can put limits on it, because it's you're giving that officer consent to search. But when we also get into where the police officer may think that you are involved in some sort of criminal activity, or there are some facts or circumstances that would lead him to believe that you're doing something wrong, that amounts to reasonable suspicion. And that allows us to do something that we call a Terry stop. Now, we can do Terry stops of people on the street. We can do Terry stops of people in cars on a traffic stop. It's basically, you see something and there's an investigative question in your mind that you need an answer to. Now, you don't have enough to arrest at this point, nor do you have enough to do a very intrusive search of the person, but you just have some questions in your mind you need to answer. And so you can stop that person for a brief encounter that is both limited in scope and duration, in order to attempt to answer your investigative question. Now, if your investigative question is then answered and it does not amount to probable cause, you got to let that person go. But if you, during the course of answering that investigative question, you now have more proof that would amount to probable cause, and probable cause can be defined as specific and articulable facts that would lead a reasonable person to believe a crime has been, is being, or is about to be committed. Then you would have that probable cause to potentially make an arrest or potentially engage in an intrusive search for the of the suspect. Now, when we do these Terry stops, and if you look in your textbook on page 344, it talks about Terry stops and the fact that It's based on reasonable suspicion. And this stems from a case in Cleveland, Ohio in the 1960s, early 1960s, where a police officer, Officer McFadden, was watching Terry and a couple other guys kind of having a little confab on an alley, and then they would talk, and one of them would come out and they'd look in the shop window, walk up and down the street for a minute, go back and they'd talk, and another one would come out and look in the shop window, and they did that several times. Well, McFadden, who had over 30 years of service as a police officer, he walks across the street and puts Terry and the others up against the wall and pats them down. Now, when I say pats them down, he does not do an intrusive search. He simply wants to make sure that they do not have a weapon, so that while he is getting them to answer his investigative question, they won't pull a gun or a knife out and hurt him or kill him. So he is engaging in a brief detention that's limited in scope, and patting down the outer clothing of the suspects. That's called a protective sweep. There's nothing wrong with that. That's what a Terry stop is. Now, you should, in your mind, after I told you about what McFadden witnessed, believe that Terry and his associates were probably getting ready to go in and rob the store. They were casing it, if you will. And so that's what McFadden believed, and that was his justification for walking across the street, making contact with them, patting them down, and then when he did pat them down, he did find a gun on Terry. And so he went in and removed the weapon, placed Terry under arrest, and at that point he had probable cause to engage in a more intrusive search of Terry and the other associates, because the probable cause level had then been reached. So read over that section on Terry. It's mentioned throughout your textbook. It's mentioned in other criminal justice classes, but it's a stop simply based on reasonable suspicion. It's limited in scope and duration for the purposes of locating weapons to make sure that the officer is safe. Okay. In regard to consensual stops, make sure that you're familiar with that free to leave test. And it says this is a test used by the courts to determine whether a situation is voluntary or not. And it is defined by the Supreme Court as follows. A person has been seized within the meaning of the Fourth Amendment only if, in the view of all the circumstances surrounding the incident, a reasonable person would believe that they were not free to leave. As long as that person believes, according to this standard, that they're free to leave, then they have not been seized, and therefore the stop is still consensual. The moment that person believes that they are no longer free to leave, that is no longer a consensual stop, and you must have, at a minimum, reasonable suspicion in order to continue detaining that person. Okay. All right. Read over the section on knock and talks. This is a really interesting way also to get some evidence in criminal cases. Basically, these are for instances where you don't have reasonable suspicion, and you think you have a pretty good idea that you believe that there's criminal activity going on inside the home, and so you would like to be able to get into the home consensually in order to see if you can see evidence of a crime. For example, if you think somebody's smoking marijuana, and they have, or maybe even selling marijuana out of this house, the likelihood that if they're selling marijuana, they're probably also smoking it as well. So therefore, it would also be likely that you may see remnants of the smoking or selling of the marijuana in the home, in plain view. But you can't just go force your way into the house. So what you do is you go up and you knock on the door. Now you have to use the door that people normally use, the one that is accessible to the public. So if that door is accessible to the public, that's the door that the police officers have to use. You go up and you knock on the door, and you tell them a little story. You say, "Hey, I'm Officer so-and-so with whatever police department. I'm investigating a crime in the neighborhood. Would you mind if I came in and talked to you for a moment?" And most of the time, people are going to be, pretty open to the idea of talking to you, especially if they don't think that the suspicion is on them at that moment. So they may invite you in. And of course, once you get in the home, then you're using your eyes and your nose and your ears and everything in order to see if there is any evidence of a crime. So let's say you're talking to the resident of the home, and you happen to see a marijuana bong sitting on the coffee table. You happen to see an ashtray with what appears to be partially burned marijuana cigarettes, more commonly referred to as roaches, in the ashtray. And you see, a couple boxes of Ziploc bags on the coffee table and a set of scales. So now that you have permission to be in the house, you have now seen evidence of a crime. Now, because it's a residence, the Fourth Amendment would apply here. So what you either have to do is ask for consent to search the remainder of the residence for evidence after you have seized what's in plain view and taken the resident into custody for that, or you can secure the residence using other officers to make sure evidence isn't destroyed and go get a search warrant. And I always say, when in doubt, get a search warrant. And it's a neat little tool. I've done probably hundreds of knock and talks, and in many cases you'll be able to get something off of that. It's just a neat little way of getting some evidence, kind of talking your way into a bad guy's house, using a ruse, if you will. It has generally been approved by the court, so it's not something that the courts look down upon, although it may be kind of right there on that line. But it is a pretty good way of getting some evidence. All right, so I talked about Terry stops already. You can read that case, that Terry versus Ohio case in 1968. In your textbook, make sure you read the importance of stop and identify laws. So let's talk for a few minutes about searches without a warrant. And the Terry stop is considered a search without a warrant. You're using reasonable suspicion in order to detain someone briefly and pat down their outer clothing, which is an inobtrusive or non-obtrusive search for the purposes of locating weapons, dangerous objects. If you happen to find other illegal contraband during that search, it is generally seizable, which means you can take it and charge that person with it. But remember, that's not the goal of a Terry stop. You're not looking for evidence, you're simply trying to protect yourself. Alright. A protective search can be made if an officer who has made a valid investigative stop has reasonable suspicion to believe that the suspect may be armed and dangerous. That's just another way of saying conduct a Terry stop. As far as during and after an arrest, if you arrest someone, which means you now have probable cause to take them into custody, those specific and articulable facts, you can search them incident to that arrest. And that means that you can search that person very intrusively. You can search them as intrusively as necessary in order to make sure they do not have any contraband on them. The only thing you cannot do is a body cavity search or a strip search on the side of the road. Strip searches are typically done in jails, and they're not done that often. And law enforcement does not do body cavity searches ever. Only a trained medical personnel can do body cavity searches at the direction of a doctor usually. Okay, so once you have made an arrest, you can search that person incident to the arrest. You can also search their immediate area of control, or also known as wingspan area, of where that person was. So if you arrest them, let's say they're in their living room on their couch, and you come in and arrest them there, you can search probably pretty much anywhere in that living room to make sure there's no weapons or contraband. If you arrest them out of a car, you can search the entire passenger compartment of the vehicle. If you arrest them out of a house, you cannot search the rest of the house, though incident to the arrest, unless you have a consent to search or a search warrant. And a car, remember, it's pretty much only the entire passenger compartment of the vehicle incident to the arrest. But if you tow the car, you have the right to inventory that vehicle as well, to make sure that the police department and you are not held liable for anything that goes missing out of that vehicle between the time that the tow truck operator takes it and they get it back. So that gives you permission to look anywhere in the vehicle for the purposes of logging down whatever is in there. And if you happen to inadvertently discover evidence, let's say in the trunk, then that is seizable. Now also, let's say you make a car stop, and during the course of the car stop you see a baggie of marijuana in the console. That is now probable cause to search that entire vehicle also, not just the passenger compartment but the entire vehicle, because probable cause has now been reached to conduct a more intrusive search because you saw something that was in plain view. All right, read over the court cases in your text. Read over that section in regard to protective sweeps. All right, just remember that there is a difference between an arrest warrant and a search warrant. An arrest warrant, you're looking for a person. In a search warrant, you're looking for evidence. Page 357 in your textbook talks about those inventory searches that I just talked about. Also make sure that you read on page 356. It talks about the different types of evidence and the authority that must exist and the means to be used to engage in those searches. That's a really good table there. Let's see here. 360, it talks about obtaining evidence by police entry into private premises. So in order to enter a home, you must either have consent, a search warrant or an arrest warrant, or emergency or exigent circumstances. So just keep that in mind, that unless somebody gives you permission, you have a warrant, or it's an emergency, you cannot just go enter somebody's house for the purposes of searching it. Michigan versus Fisher is an interesting case, though. It says that the court held that officers need only a reasonable belief an occupant of a home needs emergency aid because of an injury or threat of harm by another to enter the location without a warrant. For example, so if you look through the window and you see somebody lying on the floor, then it could be one of two things. They could be injured or dead, or they could simply be asleep on the floor. But you need to check, right? So you would have the ability at that point to kick the door in order to do a welfare check on the person that's laying on the floor. I would think that if they were injured, severely injured, they would be happy that somebody did that, to check on them. Or if they were deceased, then the family would probably be happy that somebody checked on them sooner rather than later. So just keep that in mind as well. Vehicle stops, I already told you that you could do a vehicle stop based on reasonable suspicion. That's also a Terry stop. You do not have to have probable cause to stop a vehicle. Many people get this confused. Think, well, he didn't have probable cause to stop me. You don't have to have probable cause for the police to stop you. You just have to have that reasonable suspicion. And the reason is that typically most vehicle stops are brief. They're limited in scope and duration. And the officer has an investigative question in his mind that he needs answered. The Supreme Court has also said that on any vehicle stop, if the police officer wants to make every person get out of the car, that's just fine. There's no problem with that. We can have every occupant of the vehicle may be ordered out of the vehicle as part of that stop, and you can pat every one of them down for weapons. That's an officer safety issue. Remember that. All right, evidence during traffic stops, just that understand that if you see something that is in plain view from a location that you have a legal right to be, then that evidence may be seized. And then that would give you the probable cause in order to continue that search. You can also get consent. I don't know how many times I've asked people, yeah, you care if I look in your car? And most of the time people say, no, I'll go right ahead. I don't have anything in there. I have had a few people say, yeah, you can look in it. And then they give me consent, and then when I go in there, I find their baggie of weed, and I was like, oh, I forgot I had that. So just keep that in mind. Now, understand that you do not have to get a search warrant to search a car if it is able to be immediately driven away from wherever the scene is. If it's an operable vehicle, all you have to have is probable cause or consent to search the vehicle. You just do not have to actually go get a warrant. You have to have the same amount of proof necessary to get a warrant. You just don't have to spend the time to get the warrant. All right, so read over that court case, the Carroll court case as well. And that one's actually a very important case. And I think that's going to pretty much do it. That kind of covers the high points of this chapter for this week. If you can get in your mind this idea of what it is to be free to leave, what consent is, what a Terry stop is, what the difference between reasonable and suspicion and probable cause is, and how that can apply to traffic stops and police citizen encounters, you got this chapter down. All right, guys, have a great week, and I'll see you soon. Bye-bye.